Hi, everyone, and welcome to another DARA webinar. Today, we're going to speak about worker misclassification and how we're going to turn small claims into massive settlements. Let's just give it a few more moments so people can join. Welcome, everyone, to another DARA webinar. I think we're good to start. So today, we're going to speak about worker misclassification. My name is Amit. I'm going to be your MC for today. And we are going to start off by introducing our two speakers. I'm joined by Michael Harary and Jacob Hirsch. So just a quick intro, Michael joined us at Darrow 3 years ago as a litigation partnerships executive. Michael is a licensed attorney, and prior to joining Darrow, he's had 10 years of litigation experience with a mix of commercial, employment, and IP cases. Welcome, Michael. And then we have Jacob Hirsch, who is on our Legal Intelligence Quality Counsel team, helping to ensure the legal integrity and strategic quality of Darrow's case generation platform. Jacob is a US licensed attorney with extensive experience advising businesses on complex legal, regulatory, and employment matters. And prior to working at Darrow, Jacob practiced at Proskauer Rose, focusing on labor and employment law. So welcome, Michael and Jacob. And I'd love to give a quick intro to Darrow. We are a legal intelligence company, and we specialize at discovering legal risks, assessing them, and taking actions on them. And just to sort of give an insight into what we do, I would like to show a recent legal risk that Darrow has discovered. So just this week, we discovered a labor wage and hour alleged violation. And basically, the story here was an organization that sort of promised an entrepreneurial type of work. Our system detected a potential violation involving a large direct selling company that's operated under a multi-level marketing model. But on the surface, as I said, well, it promised entrepreneurship and financial freedom. Um, and the chance for people to be their own bosses. The reality told a different story, and these people were mispaid. The result is an alleged wage and hour violation affecting 2.3K victims with the damages of 20, almost 22 million dollars. And I think that this case is just a striking example of how technology can help discover legal risks that are otherwise hidden. And Jacob and Michael will touch on that in a second. And I think that it's also a reminder that behind these big numbers and behind the data that has helped us discover this legal violation, there are a lot of human stories. Specifically in this one, many people that just wanted to be entrepreneurs and to run free and sort of work on their own go. And the fact was that it was just denied payment at the end of the day. So, with that, I'm going to hand over to our first speaker. Welcome, Michael.
Thanks, Amit. Like most of the cases we discover at Darrow, this case is a real example of the human cost behind labor violations. Impact isn't abstract, it's people's lives and income. I wanted to start off by giving a brief overview of the intersection between PAGA and arbitration. First, PAGA stands for Private Attorney General's Act. It's the California state law that allows employees to file lawsuits to recover civil penalties on behalf of themselves, other employees, and the state for certain labor code violations. PAGA actions are considered representative actions, similar to class, but with important differences. Second, as we all know, arbitration agreements are common in employee contracts. They require employees to resolve disputes through private arbitration rather than in court. However, the intersection between PAGA and arbitration, has been the subject of much legal debate and court decisions. And it's what I'd like to discuss today. First, three key decisions. Iskanian versus CSL Transportation in 2014. In this case, the California Supreme Court held that while individual wage and hour claims can be compelled to arbitration, any agreement waiving representative PAGA claims is unenforceable. Second, 2022 Viking River Cruise. The Supreme Court ruled that individual PAGA claims may be compelled to arbitration, and once compelled, plaintiff loses standing to pursue representative PAGA claims in court. And finally, and most significantly, 2023, Adolph versus Uber. In this case, the California Supreme Court took a different approach to Iskanian and held that plaintiffs who are compelled to arbitrate their individual PAGA claims do retain standing to pursue representative claims in court so long as they remain an aggrieved employee. So unless they settle or lose in arbitration. So why is Adolph so significant? Adolph not only preserved standing for plaintiffs after arbitration, but also confirmed that trial courts have broad discretion in managing PAGA cases. So courts can either stay the representative action pending the outcome of an individual arbitration, recognizing and appreciating that the result will determine standing, or allow a representative PAGA claim to proceed in parallel with the arbitration, especially where they fear fairness supports it. And that can lead to various outcomes. Some judges favor a stay to avoid duplicative process, and others permit parallel litigation to maintain pressure on the employer. So let's take a look at how the courts are actually applying Adolph in practice. In 2024, commenters started observing that most courts applying Adolph have stayed non-individual PAGA claims until the individual arbitration is completed. Experts realize and argue that Adolph preserving standing for representative claims, but don't require the courts to allow parallel litigation. Most courts agree, though, and some outlier decisions have misinterpreted this point. Recently, two Alameda County courts permitted PAGA claims to proceed alongside arbitration, not due to a misreading of Adolph, but as a discretionary choice, with one decision still tentative subject change. I want to just touch base on these a little further and in more detail. Fan versus Maple Bear. The court in Fan versus Maple Bear read the Adolph decision to mean that trial courts are allowed, but not required to stay representative PAGA claims, while the individual claims go to arbitration. The court stressed that PAGA actions are about enforcing the law on behalf of the state, not just resolving private disputes. So allowing the representative claim to move forward serves the public interest. In this case, the court concludes that running both the individual and representative claims at the same time is perfectly workable, does not undermine any process, and overlap can actually be managed by the court. The second case is the Bernstein versus Compile. Recently, in June of 2025, the Alameda County Court compelled arbitration of the individual PAGA claims, but allowed representative PAGA claims to proceed in court, following reasoning from Fan v. Maple Bear. Court reaffirmed that staying representative claims would undermine PAGA's public enforcement purpose, and that courts can effectively manage any overflow, signaling the representative PAGA claims may continue in court while the individual ones are arbitrated. Attorneys should recognize, following Adolph, the management of PAGA claims is highly dependent on the trial court's discretion. Parallel track is probably the exception and not the rule, so class representative actions will likely be stayed pending completion of the individual PAGA arbitration. Strategically, this means attorneys should be prepared to argue for or against a stay of representative PAGA claims based on specific circumstances of their cases, making sure to emphasize efficiency, judicial economy, or public interest in enforcement as appropriate. Additionally, attorneys should monitor local court trends and recent rulings, as some judges are more inclined to permit parallel proceedings, which can increase settlement leverage and maintain pressure on opposing parties. This is the state of the current litigation. I want to hand it off now to Jake, who will discuss how Darrow and Tech can help find these violations.
Thanks, Michael. Really appreciate the background there. As a labor attorney myself, been following sort of the development of this line of cases for many years. I think you did a great job of capturing the core of the issues. I just want to underscore something you said towards the end, which is, or at least that you alluded to towards the end, which is that new law on these sorts of issues is coming out every day. Courts are interpreting the higher court decisions all the time. And so it's vital for any of those of us who remain interested to be monitoring those cases as they drop and reading and reacting as the state of play changes. So anyway, I'm Jake. I am on the legal intelligence quality team here at Darrow, and I want to just zoom back a little bit and, given the framework that Michael laid out, give you a deeper sense of how we at Darrow can use tech to help identify, vet, and pursue these sorts of misclassification violations, and hopefully give you an idea of how you might be able to do that on your end too. So, jumping right into it, obviously, every case is different. These cases are comprised of employees, people's stories that vary widely. And of course, you can't have a one size fits all approach because of the human element in these lawsuits, or these potential lawsuits, I should say. But in general, we've kind of distilled the process down into these four big categories that you see on your screen here: generating a list of companies, determining the class, reviewing claim history, and of course, verifying that a violation is in fact occurring, based on publicly available information and whatever else we can scrounge up. And so, why don't we just hop in and talk about number one? So, generate a list of companies with potential violations. So, we're lucky at Darrow to have some of the best R&D talent around. Our R&D team generates a large data set of companies that have potential misclassification violations going on, obviously located in the United States, and with a particular focus on industries that tend to be reliant on independent contractor work. The data set is processed through a multi-layered filter based on information, like I mentioned, worker type, sector, the company's annual revenue, and other relevant factors. And then for each company, we use an AI-powered service to scan and analyze the evidence to assess whether that company, like I mentioned before, is actually the type that is deeply reliant on what they term independent contractor work. So we are updating this data set every 2 weeks just so that we're always staying on top of the latest and greatest potential violations that are out there, and to make sure that we have an edge over folks using more archaic forms of business development and research and analytics. So, yeah. Then from there, a crucial part of all of this story is, oh, sorry about that, is determining the class size. So of course, you have your general numerosity requirements under Rule 23. From a economic standpoint, we generally are looking at a class target, but ranging between a minimum of 1,500 employees up to about 5,000, depending on the jurisdiction, depending on the type of underlying claim. Like I'll give you, for instance, in California and PAGA, given the statutory penalties in play and some other factors that are state specific there, you don't need as many claimants. So we're talking about 1,500 as a minimum, as opposed to a state like New York or New Jersey, where we're really shooting more for that upper bound of that 5,000 plaintiff mark. Obviously, it's crucial to get in early to vet whether or not there's going to be sufficient number of plaintiffs to make a claim economical. So we're really doing this upfront, early, and often to make sure that the case actually has legs. And then, of course, as I kind of have said multiple times already, we once we've cleared those thresholds, we really need to make a determination on how many independent contractors in each relevant state actually work for that company. This provides us context in terms of how we're going to structure the case, how we're going to structure the litigation strategy to pursue the case, and just gives us a sense of of course, it's an estimate and a preliminary estimate at that, but it gives us a sense of the monetary value that's associated with the potential violation. From there, we talk about and look at the claim history for the potential defendant in the violation. So this is important for various reasons. I would say, first and foremost, we want to assess whether the eventual defendant has had has been found to have violated the law in the employment context in the past. This gives us an idea of whether they should have been on notice for purposes of punitive damages. It gives us a sense of, what other complaints that were successful looked like in terms of, getting a settlement or getting a meritorious, victorious claim in court, and just gives us sort of an idea of the lay of the land as it pertains to a specific company, and how we might adapt our strategy to account for those past violations. Beyond that, there's also kind of a business development aspect to this. If you have a company that's had a legal violation in the past and the class and the period of time that was relevant to that past violation has expired, then you're going to have a potential for the company to be ripe for a new lawsuit. And on that note, we actually have a data analyst who developed an interesting code to filter previous, recent, and current PAGA claims in a really, really fast and precise way so that we can make a really instantaneous determination as to whether or not a company with a potential PAGA violation is ripe, for lack of a better word, to be sued. And I think the other side of the coin that I kind of alluded to before here is it's not just about whether or not there was past violations, but you also, of course, have to make a determination as to whether or not there are ongoing violations that might preclude or bar your lawsuit from going forward. Obviously, if another class is already in court making allegations that you've identified, then you're sort of too late to the party. So we conduct all this analysis with various online tools, some of which you've heard of, like I don't know, the one that comes to mind is CourtLink, and others that just use our sort of AI-powered tools and technologies to be able to sort of take that information and distill it down much, much, much more quickly. From there, we then, assuming that we've cleared all those hurdles, we have a company that is extremely exposed to what they call independent contractor work. We have a potential class of a sufficient size to make the claim viable from a numerosity perspective and from an economical perspective. And we've checked claims to see what's gone on in the past and what if is or is not going on in the present. And then, of course, we have to check whether or not there's actually a violation going on. So, to do this, I would say the primary tool from a tech perspective that we use to verify whether or not these violations are taking place is Torch, which is Darrow's legal AI tool. The cool thing about Torch is that you can actually open it up on your own browser and it will interact with the page you are searching to be able to sort of think with you in real time based on what you're highlighting, what you're clicking on, what you're sort of thinking in real time as you come across a new interesting provision in a company's policies and procedures. And it's really quite fantastic. So I encourage everyone who's interested to Google Darrow Torch and give it a shot for yourself. Um, and so I think we might get to this a little bit more later, but beyond sort of looking at those policies and having Torch assist us in sort of picking apart the publicly available information that the company itself is putting out online, we also have our team combing the internet for legal intelligence as to the employees' actual individual experiences at their workplaces and kind of taking that in conjunction with the policies to piece together a story of what's actually going on at that particular workplace. And if they are consistent and we have a sufficient amount of evidence to show that the law, whether it be California, New York, New Jersey, or elsewhere, is being violated, then we move on. So when it comes to plaintiffs and actually bringing these alleged violations that have been verified into the real world, it can actually be quite daunting to manage that process from a practical standpoint. Darrow has developed a basically a one-stop shop called Plaintiff Link that is a tool that helps you streamline the plaintiff discovery and intake process and basically allows you to engage with plaintiffs and potential plaintiffs in one consolidated single interface. It's quite amazing. I mentioned before that these claims are founded on very personal individual stories from aggrieved workers, and it suffices to say that that can become a very unwieldy kind of amount of information. And so having Plaintiff Link, a one-stop shop to sort of consolidate that information and stay organized during the plaintiff process, it's invaluable. And we've seen incredible success with it thus far. And it's just sort of a way to take the theoretical, what our data and technology has allowed us to identify, and to verify it in the best way that's possible, which is to talk to people who have actually lived through the violations that we've identified. And so that sort of gets you to the end of the road. Before filing, we developed a list of companies. We verified class size and structure as it pertains to specific companies that meet our criteria and rely disproportionately on independent contractor work, or what they would call independent contractor work. We've verified the claims are not currently being alleged against that company in a court or in an arbitral proceeding that would somehow bar our filing of the claim. And we've further verified that the violation is actually going on, both by looking at the policies, looking at online testimonials and reports from workers, and by talking to plaintiffs themselves. So, with that, I will say farewell. That's all I have for you today. Thank you for taking the time. And I will just say quickly before I go that, and I think we may have a time for a few questions, but I just want to say feel free to reach out if you have any questions. We have a dedicated team here at Darrow that wants to work with you, hear your reality, and help see if there's a way to potentially help you scale up your business development efforts and partner for the long term. So thank you again and have a great day.
All right, so welcome back. Hi, Jacob and Michael. One screen, all of us. Now is the fun part of Q&As where I get to ask questions and you get to answer answers. I'm going to start off with Michael. My question to you is, what role can legal tech play in proactively identifying patterns of misclassification and surfacing of potential legal violations in that realm?
It's a good question. I think tech is a huge role. Like everything, tech is really the ability to scale. So now what we're doing, or technology allows for, is to scrape job boards, review sites. We don't have to wait for an employee to come forward, raise their hand, and say something's wrong. We're now proactively finding that employee, finding that complaint, and then building around that. I often give the analogy of like people used to complain around a water cooler, but that's a small, finite place, limited in location. So now what Darrow is doing and what technology really can do is be at every single water cooler across the country, listening in, finding out, seeing who's raising their hands virtually. And technology is really the way of the future to find these type of cases.
Awesome. Jacob, that sets the ground for the next question. That's for you. And that is, are you working on any new tech-driven tools to find these type of violations?
Yeah,
Violations,
thanks to
legal
me.
risk. Yeah.
Yeah, no, it's a good question. It kind of relates a little bit to what Michael was talking about. I mentioned before that our tools, our tech, our R&D team has the capability to cull through employment policies, employee handbooks, procedures that are publicly available online to kind of highlight the initial indications of a potential violation.
Mhm.
But that really only scratches the surface and scratches the surface, excuse me, in terms of identifying a potential violation. As Michael said, the water cooler or the analogical or proverbial water cooler is really sort of where the drama and juicy details come out. And so we're developing tools that will be able to scrape online for like Reddit and other sites where employees can come with their concerns, complain, raise their hand, as Michael said, and actually paint a fuller picture of what alleged misconduct is actually going on in the workplace. in these particular sectors. And so we're working on a tool to be able to scrape and collect that information, which is much more nuanced and difficult to wrap our heads around. But we've actually already started doing this and have had surprisingly accurate and good results. So now the idea is to just scale that capability up. And yeah, we'll keep you posted on how that goes.
I love the reference to the water cooler with the waterfall behind you. It just hit me. Exactly. Here's the waterfall. I have horses. What does that mean? Um, Perfect. So thank you both, and thank you for everyone joining us. We will send you a recording of this webinar to your email. And if you have any comments, thoughts, if you'd like to see our platform and legal risks like the one I showed at the beginning of this webinar, we'd love to be in touch and you can just respond to it. And we hope to see you again in the future. Michael and Jacob, thank you for joining me today. Um, Bye.
Bye. Thank you.